So just to give you all a little bit of background information, and some of you may be wondering, what the heck is HIPAA? So HIPAA is the Health Insurance Portability and Accountability Act, which sets the standards for how we should be protecting sensitive patient data. It also governs what the proper measures are for securing that information, making sure that our standards are in place and that we're following them. In order to become HIPAA compliant, there have been several steps that we've had to take, and we've engaged Ken Rashbaum, who will shortly be speaking here to us today, to help us meet that goal. This was an effort that started some time ago, and Tamir was working on it, and then when Tamir left, I took up in his place, and we're very quickly reaching our goal of becoming HIPAA compliant. So with that, Ken, feel free to take on.
Okay, thank you, Brenda. Good day to everybody. As Brenda said, my name is Ken Rashbaum. I'm an attorney in New York City, and I am ZyLab's HIPAA counsel. Some of you may have seen HIPAA training presentations before. We did the last one in early 2015, but the requirements are that the training be done on a yearly basis. This session is being recorded for those who can't make it, as well as for new employee orientation. The other reason we're doing the training now is there have been significant changes in the HIPAA regulations in the last year. So we'll be spending time on that and the changes in some of ZyLab's protocols as a result of these new regulations. If you have questions, as Brenda said, please unmute yourself and ask them. I will leave some time at the end as well. I will also provide at the end my contact information. If you think of a question later on that you did not think to ask during the session, please feel free to send me an email, and I will be happy to respond. Okay, so there are a number of ways in which the United States comes by its law. We have statutes which are similar to the codes in the Netherlands and other parts of Europe. We have regulations by federal agencies, and the HIPAA regulations come from a federal agency known as the U.S. Department of Health and Human Services. And we have a third method in which we get the law, which is the evolution of proceedings brought under these regulations, and that has brought about the most significant change in the HIPAA law, the law of privacy and security of health information, since we did the last training, and I will be going through that in some detail. Now, the last time we did this training, ZyLab was not working with hospitals or health plans in the United States to any great extent. Now it is. One of your new clients is OSF Healthcare System in the state of Illinois. My understanding is that the sales team has been working with hospital systems in other states as well. So the timing for this is very good. HIPAA covers health plans, health insurance plans, and many of you know that in the United States, most health insurance is provided by private organizations, insurance companies who provide health plans. It's somewhat similar to the system in the Netherlands, although of course there are significant differences as well that we don't need to go into here. But for a health care provider like a hospital system, a medical practice, a laboratory system, or a health plan, to engage an organization like ZyLab, those entities must first assure that ZyLab meets the HIPAA requirements. They cannot hire you unless you meet those requirements. So the business in this area, and there is an increasing amount of business in health information management and electronic discovery from health providers and health plans in the United States. It has been growing exponentially through the transfer of medical records in the U.S. from paper to digital. $3.5 billion U.S. was designated in 2009 for a national transition to electronic medical records. That transition is not complete yet, but it is accelerating because of the subsidies provided to make these changes. Why is this important to ZyLab? Because your expertise in electronic discovery is what is motivating these hospital systems and health plans to call ZyLab to assist in litigation or government investigations that will require electronic medical records. Again, to do all this, the law requires that ZyLab meet certain requirements in HIPAA. It also requires that it meets certain requirements in state laws. The U.S. is somewhat unique in that the system of laws here runs on at least two levels: federal law, which covers the entire country, and state law. We have 50 states plus the District of Columbia and the Commonwealth of Puerto Rico. The laws of each state differ dramatically. There are state privacy laws that will affect your work in e-discovery for medical information. If those laws are stricter than the HIPAA standards, they prevail and they must be followed. The three states with the strictest laws are California, Massachusetts, and New York. We'll get into some of these distinctions a little bit later, California being the one we're going to focus on because there are, to my understanding, significant sales efforts going on in the state of California, and California has adopted strict HIPAA security requirements. The focus recently in enforcement has been on security. This makes sense because the security rule of HIPAA states in its preamble that security enables privacy. This may start to sound familiar to many of you, and if it does, there's a good reason for it. The HIPAA rules were derived largely from the European Union privacy directives. Provisions such as authorization and consent for use or disclosure of personal information, the ability to amend or correct records, security provisions around these protections for records were based in European privacy law. This is a little-known fact in the United States, but I work in cross-border data privacy and data protection and work with many multinational organizations, so I see the similarities very clearly, and it helps in an understanding of these rules. I will tell you that the HIPAA rules and their commentary comprise almost 2,000 pages of regulations. But because of my experience knowing the derivation of these rules, I can distill these rules down to this session and the policies and procedures that we have already written for ZyLab. The HIPAA initiative started in early 2015 under Tamir, under Mary Mack when she was with ZyLab and many others, because of the anticipation of the new business that would come to ZyLab with the transfer to electronic records. This is now starting to gain traction. It is accelerating. You will be doing a lot of business in healthcare, and this is a very good thing. But we need to have these procedures in place because enforcement of the HIPAA rules has also been accelerating. For the last year and a half, some of you may be familiar with the sequester in the United States because of budget concerns at the federal level. Many federal agencies had frozen budgets, hiring freezes, and were not permitted to expand their enforcement reach. The HIPAA is enforced by an agency known as the Office for Civil Rights of the United States Department of Health and Human Services. Focus on that name for a second, the Office for Civil Rights. This again may ring some bells in the minds of some of you because the data protection authorities in Europe have similar names. In Italy, the guarantee, the name, the Garante, is the Data Protection Authority. It translates the full name into the Guarantee for Personal Rights. The CNIL in France, the Center for the National Institute for Liberty. Again, that's the Data Protection Authority in France. The name tells you the seriousness with which the country takes these regulations. The U.S. does not have overarching privacy law that covers all industries, as one sees in Canada or in Europe, or even for that matter in many South American countries. Our privacy law is segmented by industry, and our national privacy law is found in 3 industries: healthcare, finance, financial organizations, and education, particularly higher education, but it extends to all levels. Not only has the Office for Civil Rights been excluded from the budget freeze at the federal level, it has received new funding. I know this because I am on the listserv for the Office for Civil Rights, and I receive the vacancy notices indicating that they are hiring new enforcement personnel. I get these notices regularly. Also, I get the notices when there have been settlements of HIPAA penalties. If there is a breach of personal health and protected health information, and I'll get into that definition in a moment, a complaint may be made to the Office for Civil Rights, which then investigates. If violations are found, the Office for Civil Rights can initiate proceedings for civil monetary penalties. They do so regularly and publish their findings approximately once each month. I will talk in a moment about one particular penalty proceeding that came down 3 days ago. The penalties have risen to a record high of $5,500,000 United States dollars. There are, of course, many lower penalties, but many of the penalties involve entities who are HIPAA business associates like ZyLab, and we're going to talk about those in just a minute. But on the screen now, you see some of the main foundations for HIPAA penalty procedures. These are the reasons why the penalties get so high. Absent or insufficient business associate agreements, contracts entities like ZyLab sign with hospitals or health plans, a lack of current training, no documentation of the or conduct of the sort of training we are doing now on an annual basis. And Brenda and Dennis and I have discussed the need to document this training, not just for those who are on the call now, but for those who received the training later in recorded fashion because they couldn't attend today, or those who received the training as part of the new employee orientation. Another area for investigation and penalty proceedings is lack of encryption. HIPAA requires encryption at rest, meaning in storage, and in motion. We'll talk in a few minutes about how ZyLab new policies are addressing this issue. Failure to maintain and update breach response protocols, malware prevention and remediation, and also a failure to have a risk management program for security. Because most of the records now and going forward that you will be involved in are electronic, security and privacy go together. If you don't have good security, you can't have privacy protection with regard to electronic information. This is common sense, and the government has now adopted this in a very significant way. I have up here a quote from Jocelyn Samuels, who is the director of the Office for Civil Rights, and you see the date here. What I am going to be talking to you about today is current within the last 30 days. Sometimes these regulations and these proceedings change because of new settlement procedures, and I will be advising ZyLab on that when it occurs and affects ZyLab's business. But look at the, if you would, the provision in italics. OCR, the Office for Civil Rights, is laser focused on breaches occurring at healthcare entities and any issues that lead to them. The enforcement work is focused on investigating the root causes of these breaches. So what happens in an OCR investigation is it starts usually with something small. It's like a USB that was unencrypted, a thumb drive that was lost and had the names and medical information of patients, or a tablet or a laptop stolen from the back of someone's car, and again not being encrypted. You'll see there are recurring themes with a lot of these breaches. But let me talk about one that was reported only 3 days ago to give you the idea of the extent of the aggressiveness of OCR's investigation. In this instance, a hospital in the southwest of the United States bought a new server. It did not have the server analyzed before it put it online. As a default, the server had a file sharing application that made all information on the server available through the internet. 31,800 patients' full medical records were available once the server went online through Google. If you Googled the hospital or you Googled the name of the patient, you got that information. This is not the first time this has happened. A few years ago in New York City, one of the most renowned hospitals, Columbia Presbyterian Medical Center, was fined $4,125,000 because of a breach involving 7,800 patients whose names got on the internet and were available for Google search. The way this occurred is that a researcher from Columbia University had connected his laptop to the hospital network. When he took down the laptop, he neglected to take down certain commands that would keep the spiders, the web crawling algorithms from Google and Yahoo and certain other internet providers out of the system. This was discovered when the partner of a patient who had died in the hospital, in her grief, Googled the name of her partner. Needless to say, she was quite surprised when she came up with a hit for the hospital. Upon clicking on the hit, she was even more surprised to find the entire medical record. The entire medical record in unencrypted, clear text. $3 million of this fine was levied against the hospital, the rest against the university. There are many more of these penalty proceedings. I'm not going to discuss them here because I think you get the idea of the way in which this is being monitored. Because one of the things electronic records has allowed is for the investigatory agencies like OCR to audit hospitals and those who work with them remotely. They don't have to send agents on a plane or a train to the office of the hospital or those who work with them. They can do this online from their desks. Let me pause for a moment and touch on something Brenda had mentioned earlier. I want to do a brief recap of the HIPAA regulations for those who may not recall some of the details, and I won't spend a lot of time on this because you have it in the previous training. But let me start off with what the acronym HIPAA stands for. It stands for the Health Insurance Portability and Accountability Act of 1996. Look at that date closely. These rules were written in the 1990s. This is a lifetime ago in terms of electronic information and technology. Any of you come to New York, you're welcome to come visit my office, and I will show you, which I keep here for the benefit of my younger colleagues, my first cell phone, which is about the size and weight of a brick. Needless to say, we have moved on dramatically since then. But the rules have been updated through guidance documents from OCR and these penalty findings we've been discussing. But HIPAA was designed to cover healthcare providers, health insurance plans, and a third category we haven't talked about yet, business associates. In 2013, HIPAA was amended to directly cover business associates. Now, what's a business associate? ZyLab is one. A business associate is any organization or individual who accesses protected health information to perform a service for a covered entity, a healthcare provider, or a health plan. When I say access, I use the term as loosely as it is used in the European Union privacy directives. I mean just viewing the information. Processing is a term in the EU privacy directives that we will not find in HIPAA. Processing means any manipulation or use of the data. HIPAA doesn't speak in terms of processing, it talks about use. And use is access. If you view the data, you are using it. For e-discovery and information governance work you will be doing with hospitals in the U.S., you fall into this category. You are using that information. Now, I've used the term protected health information. That is defined in HIPAA. Protected health information is very broad. It is information involving the medical condition or medical treatment of an individual in the past, present, or future. What do I mean by future? What I mean by future is a prognosis, a medical treatment plan, appointments for medical treatment. Those fall into the category of future. Now, this is information in any electronic form, not just the actual medical record. It could be in a text, it could be in a blog post, it could be in an email, and it is tied to the patient. This is the individually identifiable part of it, by any one of 18 identifiers. These identifiers include things that are obvious, like name and social security number, which is our national identifying number here in the U.S., medical record number, but it also includes things you might not normally think of as an identifier. A photograph, for example. Many of the medical records you will be working with will have photographs, because photographs are essential in some aspects of medical treatment. My background in healthcare goes back many, many years. I have represented health insurance companies, hospitals, individual physicians, hospital administrators in compliance with U.S. regulations, in litigation, in government investigation. So I am very familiar with uses of medical information in e-discovery, information governance, and in medical care. You'll find as you work with hospitals that it's very difficult to draw a sharp line between the uses of information for medical care and the uses in e-discovery and information governance. Hospitals are very decentralized in how they keep electronic information. Different departments will keep information and not tell the Central Medical Records Department. So when you go in to do a collection, if you're going to do a collection or processing of information, you're going to have many different people you need to speak with and many different places to look. Protected health information includes email. You're very familiar as a company with how to process email for e-discovery. This will be expanded now to text messages. It will be expanded to the proprietary messaging systems of the individual hospitals and the departments in the individual hospitals. And the question may come up, is something PHI? I will advise you that the default answer to that question should be yes, it is, unless proven otherwise. If you have questions of whether certain information is PHI, you can talk to Dennis or Brenda. They can bring the question to me. But the general rule is medical information that can be tied to a patient by one of these identifiers is protected information. There are certain safe harbors for this information, including de-identification, anonymization of the data, removal of the 18 identifiers, or encryption. HIPAA comprises two rules, the privacy rule and the security rule. We went into this at the last training, but let's just go back through it for a moment just on this slide. The privacy rule is similar to the privacy laws in Europe. Safeguards for information, access to that information requiring consent, and exceptions to that in the rule. One similarity between the European privacy directives and HIPAA is that both are standards of exclusion and prohibition. What by that I mean, the general rule is you may not access personal data in Europe. You may not access protected health information in the U.S. unless the regulation says you may do so. And HIPAA provides certain exceptions to that rule where consent is not necessary. One of them is defensive lawsuits. So when you're collecting and processing information for litigation purposes, you will not have to ask for patient consent. All right? The hospital will take care of that information for you. I won't get down into the details of this any further. The HIPAA security rule is physical, technical, and administrative safeguards for electronic health information. Physical is locks and keys and cameras. Technical is encryption and other technical safeguards, malware prevention, for example. Administrative means policies, procedures, and training like we're doing now. HIPAA business associates, as of 2013, are directly covered by HIPAA. Earlier this year, there was a $550,000 HIPAA fine levied against a business associate. Most of the HIPAA proceedings I've talked about have been against the hospitals or the health plans. And earlier this year was the very first one against a business associate for a breach, for failing to safeguard the information that it held. Another thing that is different since 2013 is state attorneys general. The attorney general of a U.S. state can bring an action for a HIPAA violation if OCR, the Office for Civil Rights, declines to do so. Many of them have, particularly in the states of Connecticut, California, and Illinois. So we don't just have to be concerned about the federal level, we have to worry about state attorney generals, and we'll talk about state privacy law investigations later. Recently, the Office for Civil Rights has started surprise audits of business associates. That means that if you're selected for audit, you will get a questionnaire. Usually it's very long, asking you the company to respond about its protocols for securing information. Round 1 was last year. Round 2 started October 4th. Hopefully ZyLab will not be selected for one of these audits, since so far you're not doing that much work with hospitals. But you are potentially a target for an audit at any time. HIPAA requires that when ZyLab or any other business associate does work with a covered entity, a health plan or a healthcare provider, it must enter into a contract called a HIPAA Business Associate Agreement. The agreement says that ZyLab will maintain policies and procedures, including breach prevention and training like this, to meet the requirements of HIPAA, and will report security incidents, meaning attempted breaches, or breaches, attempted attacks rather, or breaches themselves to the covered entity. Many of your hospitals will have business associates they ask you to sign. HIPAA requires certain clauses in those agreements. I have provided for ZyLab a template business associate agreement in the event that your hospital client or health insurance plan client doesn't have one. And also, if it does and gives one to ZyLab, you can compare that against the template agreement that I've given you. In August of this year, there was a new requirement that the business associate has the responsibility to make sure this agreement is in place. Prior to August of 2016, the responsibility was on the covered entity to get the agreement in place, but in August, OCR issued a penalty proceeding, I believe it was $350,000, against the business associate for not having the agreement in place. So if you have a hospital medical practice or a client who is a software developer, you may get software developer clients who are doing medical billing software, for example, or imaging software, and they may ask you to help them if they are sued or the subject of a government investigation and e-discovery. You would need a business associate agreement with them as well. In September, OCR clarified that a business associate is any entity that accesses, receives, hosts, or uses PHI. If some point in the future you go to a cloud provider solution for your work with hospitals or medical practices or health insurance plans, you will need to have a business associate agreement with that cloud provider. I write these agreements for cloud providers, I negotiate them, and in fact I have a client who is a cloud provider. So this is new. So just keep that in mind if you move to that solution. For these new rules and these new potential clients, new policies have come into effect for ZyLab. And here is the first one. ZyLab will not be accepting any PHI for upload unless it's encrypted or de-identified. And the reason for that is that HIPAA requires encryption at rest. If you encrypt at your servers, my understanding from Dennis and others is that that would slow down the servers to an extent that it would interfere with your business with other clients. So not encrypting at rest is a business decision, and it is an appropriate one. But it requires certain HIPAA precautions. And one of these is that your agreements with hospitals and health insurance plans and others in the healthcare industry will have a provision that no PHI will be sent to you unless it's encrypted or de-identified. You're not the first of my clients to ask for this. I've seen this on a number of occasions. I just completed a set of agreements for a security consultants organization in Canada that has the same policy. Now that said, while I have indicated that the policy of ZyLab will be not to accept any PHI that is identifiable, I will tell you that in my experience, it's almost impossible to enforce that. Because of the multiple gigabytes, sometimes even terabytes, of information that you will be processing, some identifiable PHI, protected health information, is going to slip through. So we need to have backup precautions on how to handle any identifiable health information that you get. So here are some, on the screen now, are some new policies. One of which is the computer monitors must be turned away from the windows. There has actually been a breach reported in the United States of someone who took a photograph of a computer monitor with PHI through a window and put it on the internet. Some of these precautions may strike you as an overabundance of caution. I can tell you from personal experience, this is not one of them. In fact, one of my medical practice clients from here in Manhattan in New York City called me and retained my services after he had to fire a billing clerk, terminate the employment of a billing clerk who took a picture of herself in front of her screen with all the patient's information up on the screen and posted it to Instagram with a caption that said, "Another boring day at work." The information on her screen was identifiable to patient names and the procedures that they had done and how much they were billed for those medical procedures. Obviously, this was something we had to report. It became a huge problem, and I was retained to create a set of policies and procedures for the medical practice and to do training for them. This was 3 years ago. They remain a client to this date for updates of the HIPAA rules and for incidents that still occur. Slack is something we need to address. Your office uses Slack, so does mine. So do a lot of offices in Europe and the United States. We have instituted a policy that no PHI is to be communicated on Slack. The reason for this is that Slack does not encrypt at rest. I know this because I have personally spoken to Slack's compliance officer, and she told me that Slack does not encrypt at rest and does not plan to do so because it will slow down its search capabilities. Now, I said before that while you're not accepting PHI that is identifiable, some will undoubtedly slip through. And it may be you may think, well, I've just gotten some PHI, what do? I know, I'm going to ask Dennis, and I'm going to ask him on Slack. Please don't do that. Slack does not encrypt at rest. It is a HIPAA violation to put the names and information of patients, medical information of patients, on Slack. That's why we have that, and that is going to be enforced. We talked about the administrative safeguards of HIPAA. They are these written procedures that we are talking about that I first drafted in collaboration with some of your colleagues in 2015 and this year have updated. The HIPAA procedures will be available to you in an intranet, probably in hard copy as well, and I want to emphasize that they are living documents, just as they were changed this year because of changes in technology and regulatory changes. They will be revised in the future, and also because of practical aspects. If Brenda or Dennis or Galeb call me and say, you know what, these policies are just not working in practice, we will revise them. Because HIPAA requires an annual assessment of these policies and procedures and your technical security precautions and revision if necessary. This has to be done on an annual basis. We just completed it last week for 2016. If you do find that you have received PHI, you should notify the project manager immediately, and the project manager will escalate that concern to the privacy and security officer. But if you see that PHI is in your system, there are some precautions that must be taken. If you have to communicate about that PHI, that communication should be encrypted in motion. PHI should never, ever be sent over personal email accounts, Gmail, for example. Not only is Gmail unsecure because it's not encrypted, Google has had its executives testify in court cases in the state of California that Google monitors and accesses every email in the United States, either by algorithm or by a human being. Yahoo has recently disclosed that it has allowed surveillance from the National Security Agency, familiar to those of you who have followed the disclosures of Edward Snowden and WikiLeaks for that matter. So Yahoo monitors information. That is a HIPAA violation if identifiable medical information is sent by you on these personal email accounts. Portable media is addressed in the policies and procedures. I won't go into that in much detail now, except to state that if there is any PHI on a portable device, it must be encrypted. You should not be using portable devices to store PHI unless you have explicit permission from the ZyLab security officer, and steps have been taken to make sure that you either have an encrypted folder on the desktop or there is some other way to make sure that if that device is lost, no one can get into the PHI. Social media, a lot of this is common sense on this screen, but if you do come across PHI, you may well come across PHI of a celebrity. You may come across PHI of a politician. This has happened. I'll give you two examples. In 2007, George Clooney was in a motorcycle accident in the state of New Jersey. He and his then girlfriend were taken by ambulance to a hospital. Word got out that George Clooney was in the house, and there were 17 attempts to get into his electronic medical record. One of the things HIPAA requires in electronic medical records is a form of metadata known as an audit trail. An audit trail, as you all know, discloses who has been in that particular record and when he or she did so. So all of these employees' identities were, of course, discovered through their passwords, and they were suspended from employment for 30 days. Move forward a few years, former President Bill Clinton was admitted to Columbia Presbyterian Medical Center for heart surgery, open heart cardiac surgery. There were multiple attempts to get into his medical record. However, Columbia Presbyterian Hospital had put President Clinton's electronic medical record under a fake identifier. As a result, no one was able to gain access into his medical record. So just understand that no patient information is to be placed on any form of social media at any time. If there is a breach of PHI, there are rules here on this slide that talk about how breaches are to be treated. A breach is an unauthorized disclosure, meaning not authorized by the patient, of unsecured PHI. Unsecured PHI is that which has not been encrypted. There are significant notification tasks required. If there is a breach by ZyLab, ZyLab will not make the notification. It will instead notify its client, with the significant exception that certain states like New Jersey and New York would require ZyLab to make that disclosure. If you do have a breach, my strong suggestion would be to have the privacy officer or the security officer, or both, contact me, and as your HIPAA counsel, I will advise on what notifications need to be made, to whom, and within what time period. I mentioned there are privacy laws of 47 of the 50 states. Those laws differ as to the timing in which one must notify a patient of a breach. It goes from a low of 7 days in the state of Maine to 30 days in Massachusetts to as soon as practicable in most other states. It is a multi-level analysis of what one must do in the event of a breach to comply with federal and state laws, and I will function as the breach coach in the event that you have a breach. Other aspects of the law that have changed in 2016 include a risk management plan for malware, which ZyLab has, and I have seen it, and it's very comprehensive. It needs to be maintained on a current basis. Pursuant to the July 2016 ransomware fact sheet that set out standards for malware detection. That is available on the website, which I will give you at the end. One point I want everyone to take away is that security is everybody's obligation when you're working with healthcare organizations. It's not just a matter for the security officer or the security group. It's a matter for everybody, and that is what is embedded in the HIPAA regulations. Okay, we talked about this slide, so I'm going to skip over it. State laws, as I mentioned at the beginning, will be the law that has to be followed if it is stricter than HIPAA. Let me pause on this for a second and make the analogy once again to laws you are familiar with, which are Netherlands privacy law and the European Union privacy directives, and soon to be the GDPR, the General Data Protection Regulation, which will come into effect in May of 2018. All of those the directives in particular, are minimum standards of privacy. Every member state in the European Union must enable the European Union privacy directives by laws which enable those privacy safeguards but can be stricter than those safeguards. HIPAA works the same way. State laws that are stricter than HIPAA apply as a supplement to the HIPAA rules and must be followed. The three states I mentioned that come to mind most frequently are California, Massachusetts, and New York. California's Attorney General in February of this year issued a report indicating that the state of California will consider the 21 safeguards for the Organization for Information Security as minimum standards of security for personally identifiable information in the state. Brenda and I have talked about this because there are sales efforts being made in California, and that if you work with California hospital systems or health plans, you'll need to be familiar with these particular security regulations, and they may in fact be embedded in your contract for e-discovery or information governance with those hospitals. So again, state laws need to be kept in mind. If your contract, your service level agreement or your master service agreement with the hospital has a requirement for minimum standards of security pursuant to certain state laws in the U.S., please let me know if that agreement is being negotiated, because some of those controls may not apply to ZyLab, and I will be happy to make the argument to the hospital system or health plan that you should not be bound by them. If you have questions or want to look further into these requirements and regulations, here are some websites that are helpful. One is the hhs.gov OCR privacy, which will provide overall view on the HIPAA rules. The audit program is in that second link, and the guidance documents, we talked about malware, for example, there are many others, are on this website linked here. My contact information is on this slide. On our website, which is the third bullet, we have a privacy and cybersecurity blog where I write on a regular basis about HIPAA issues. Feel free to consult that. Those blog posts usually get uploaded to Twitter as well. So at this point, let me ask if there are any questions. Brenda, I saw that you indicated that there may be one.
Yes, so Ralph had posed a question. Can you tell us any e-discovery software that does store data encrypted at rest? Are you aware of any?
I'm going to have to get back to you on that. I have seen certain, let me back up for a second. I have seen certain types of software that do encrypt at rest, but I am a little bit reluctant to mention them at this point for two reasons. One is I'm not sure they'd be compatible with your systems, and two, I've been advised that ZyLab doesn't want to, for business reasons, encrypt data at rest in the servers because of the potential of slowing down the operation of the servers. But I will tell you that some of my clients segment their servers using VMware so that they will have a virtualized server, if you will, that they use for encrypting data at rest, and in that way it doesn't interfere with the overall operation of the server for other clients. Ralph, I don't know if that answers your question.
Yeah, so let's start from the first question that I want to ask, and I was confused about this when we launched this whole HIPAA program. In the U.S., so you're familiar with the e-discovery business. In the U.S., we do not provide an e-discovery service, and we're going to start doing that. But 100% of our business, we are very much like buy Microsoft Access off the shelf, and you install it on premises. And I wouldn't think Microsoft would have to have a HIPAA agreement for that type of program. We don't know what data goes in it. We don't process the data. We don't look at the data. We don't review the data. It's all on the customer's premises. It's not even in our custody at all. So when you're talking about our business, at least in the U.S., that's not our business. Our business is installing the software and at the hospital, and then they do with it what they want. So I would think that the only time in that particular business model, the only time that HIPAA and the business associate agreement becomes pertinent to us are in two cases, or really one case, when we're installing the software and maybe come across data that the client is testing, or if we're troubleshooting. Those are the only two cases, because those other cases, they shouldn't be ever sending data to us. Yeah.
You're absolutely right, and therefore this training is about, because basically when you talk about what you just stated, we have two departments that are explicitly exposed to this. It's one, our customer support department. On the moment they get any HIPAA data on our premise, we need to apply the rules that Ken just presented. That's one. The other one, on the moment we bring along any of the data during an installation on the laptop of our PS colleagues, we have another breach, because that's not allowed, because our policy is that we only use. So it's equally as we work with Rentec, it is on their premise, we will not be exposed. Even not, as we just stated, the window example is on the moment we get a go-to meeting, we need to make sure nothing is exposed. That's the main mental state of this presentation, that everybody is aware that we will never utilize it outside the premise of the customer.
I think that's cool. Sorry, go ahead.
Yeah, so I just want to make sure that we have support when we see these business associate agreements. They don't seem to really be for us, and there should be ways for Dennis, for us to mitigate our exposure in these agreements.
Ralph,
go ahead, Ken.
Couple of thoughts. You both are absolutely correct. These are the times in which, if at all, that you will come across a PHI. Troubleshooting, as you mentioned, in quality, which goes under the category as well as quality control. Installation, or if the customer asks to upload the information to you because they are having some particular difficulty. But all three of those possibilities fall under the rubric of HIPAA, because the way OCR has been going lately, and remember there's a body of law based on the settlement proceedings, is if you have access to the PHI, not if you're actually taking it, if you have access to it, if you have the opportunity to view it, you are a business associate. Now, is there going to be some case where you won't be a business associate? Yes, there probably will be. And if that's the case, Ralph and Dennis, you will want to think about that and say, hey, wait a minute, maybe we shouldn't sign a business associate agreement. Although, Ralph, I will tell you that Microsoft does sign business associate agreements because I've entered into them.
Oh, I know. I understand Microsoft does, but there's a lot of other reasons for it. If you just took it that we're just software that's installed, right? We don't really have the ability to look at their data unless they give us access to do so. Why don't we just not do so, right, in many cases, or have a very controlled protocol to send back to them in these business associated agreements such that.
Yeah, if you can do that, that's fine. And, look, I'm happy to make that, as your HIPAA counsel, I'm very happy to make the argument for you with counsel for the hospital that, you know what, HIPAA just doesn't apply here. But I will tell you that having worked in healthcare for a very long time and been at the forefront of HIPAA, I was HIPAA counsel for some of the largest systems in New York from 2000 to 2004 when HIPAA first came on the scene. There is a tremendous fear of these fines and proceedings because the fines I mentioned are not the total expense to the hospital. They are the beginning. The fines, the total expense includes legal fees for defending the proceeding. It includes bringing in consultants to meet corrective action plans because every single one of these reported violations and fines comes with a minimum 2-year corrective action plan where certain standards have to be met and reported to the federal government. You're talking about hundreds of thousands of dollars of additional expense, and I must tell you, and for those of you on the call, the economics of healthcare in the U.S. are difficult. Hospitals run on very thin margins, profit margins, because reimbursement from Medicaid, Medicare, and private insurers is very slow and in many instances is being reduced. So there is a fear from the Office of Risk Management and Compliance of HIPAA in these hospitals. These fines can bankrupt certain hospitals, and so they take the path of least resistance, Ralph. They will say, we want these agreements in place because there is a remote possibility you may have these you may have access, and therefore if you have access you may have a breach, and the breach may come back to us if there is a penalty proceeding, and therefore we will only give the business to e-discovery companies that are HIPAA compliant. That's just the state of play in the healthcare industry in the U.S.
I got it. We can take this offline. I think that we can do a better job in negotiating these agreements and training the people in what we have to say when we get them. I mean, specifically my sales team, because the access component is very limited, very limited. And then we should change.
No. I think. I'm sure you're right, and the scope of the risk is very limited. We did a full risk analysis to make sure we are not being exposed. We have a low exposure, nevertheless, to be compliant and to get the bloody certificate, we need to go through this procedure and make sure we are also prepared for the audit. And in that sense, agreed. So let's shut down this training because a lot of people are on the line. That basically we need to go through the yearly update on what's going on in HIPAA land, and in that sense, I just want to thank Ken for giving us this update, making sure we are on par again, and we can move on to make sure we're compliant. And indeed, the only thing you all need to remember that when you talk about PHI, it's very important information, and we need to comply that we don't accept that data going forward from a PS and a CS standpoint. When you all remember that one, then we are very much very compliant, and the rest will take care of some of the policies we send out. So that's at least what I want you all to remember. And indeed, from a Ralph standpoint, is make sure that contractual we are limited exposed. Then it's even a swell job there. And when we need some support, then Ken will be also available. So that, in my opinion, that's it. I wanna ask Ken if you want to add any others to this.
No, I don't have anything else. I want to thank everybody for attending. And if anyone has a question or a concern they want to take offline, you have my contact information on this screen. Please feel free to let me know.
All right, then I want to thank you very much, Ken, and we'll probably speak soon again for the next step.
Okay, thank you, Dennis. All right, everybody, enjoy the rest of your day.
Thank you, Brandon, for organizing. Thank you all for attending. Ciao. Have a good weekend.